Yeah, Your Lordship. I'd like to mention here item number 3 of this list, Lordship. This matter is Parkhat matter, Lordship, but I have been informed by the PP that he is having some medical problem, Lordship.
Okay.
That so he has paid for fixing the matter on 29th or 30th. On 29th, Monday, Your Lordship may fix the Parkhat. He will address on that day, Lordship.
Mr. Das,
Das.
you are praying for an adjournment. Heard Mr. K.K. Das, learned counsel for the petitioner, also heard Mr. A. Ahmed, learned additional public prosecutor. Learned additional public prosecutor has prayed for an adjournment today as the
Kuldeep
conducting public prosecutor, Mr. D.
Kuldeep
Das,
Bush.
Mr.
Kuldeep Bush, sir.
Kuldeep Busho has some personal difficulty today. Considering the grounds, the prayer is allowed. Let this matter be listed on
29th.
30th. Oh,
As part of-
on 29 January as part of matter.
Item 1 to 3 for hearing. Say please, Your Lordship. As Your Lordship, I have prepared written submission, Your Lordship. The Chancellor of Justice, Lordship.
You have to finish it today.
I'll do it. That's why I've made it, Your Lordship, compilation, everything is there. No. Because I have seen the case records in the samples, Your Lordship. That's why D1 they have to about it. So if Your Lordship permit, I can file my compilation to Your Lordship if Your Lordship permits me. Because the records which have come, it's very difficult to see the thing. Well, I have indexed it and made copies out. If Your Lordship permits me, I can file it later on, Your Lordship, for
Okay.
your convenience, Your Lordship.
Okay. It will,
Because otherwise, Your Lordship won't be able to pay.
if it helps the court.
Yeah, definitely. I prepared, I'll get it photocopied and give it to Your Lordship. All the charge sheet documents are there. 20 volumes, all are there. Compiled indexing it. That I'll file it later, Your Lordship. Your Lordship, here what has happened, if Your Lordship see. The criminal case lodged against the petitioner was on the ground
Now we are taking up
27, Your Lordship.
criminal petition 27.
Yeah, see 27. Because 11 is over, Your Lordship.
Yes.
27 you are taking, Your Lordship. So this matter requires some serious legal issues, Your Lordship. Because in the suspension order, Your Lordship, same DP and this thing has happened. The allegation made against me was that I didn't allow them to make GD orally, make GD entry. The vehicle was released, the accused was released, and the fourth is that this contraband were kept in my custody. And if you Lordship see the charge sheet has not dealt with the first three because that means there is no evidence against that. Only in the respect of fourth thing, keeping in personal care custody of the
Okay. How many cases are clubbed together? 3 cases.
3 cases, Your Lordship.
Third one is
Third one is that FIR thing, Your Lordship. That is linked up with this. The
now
quashing of-
in this criminal petition 27.
Yes, Your Lordship.
What relief you are seeking?
Quashing of the charge sheet and criminal proceeding, Your Lordship. And that because 5 is 5 will 5 only for one purpose that will be required. That is that IA number 5. Otherwise, it will be covered by this matter, Your Lordship. Because that is that in that matter, Your Lordship, the records the first charge sheet was taken back by the from the court by the IO, Your Lordship, and that was replaced by a second charge sheet at later on. That will come to later on, Your Lordship. That will be covered by this matter itself. So, Your Lordship, it is that the seized contraband was kept on my custody. That was the only thing, Your Lordship. Now, here, Your Lordship, they try to blame me on the ground that here, Your Lordship, the OC of the police station is in the rank of SSP and is an IPS officer, Your Lordship, not an ordinary inspector, Your Lordship. she had made an allegation that I orally said not to raise an FIR, release the accused, release the vehicle on Jimanova, all this allegation, but there's no record to that. Then your lordship will see it's a peculiar fact. Your lordship, what happened in the charge sheet? It is charge sheet. They for the first time they have made a category statistic that DD entries were made on 6 because they say they according to them, I took the drugs on from on 6/8/2018 one packet, then on 17/8/2018 another 10 packets. But the call data records which they have produced shows that I was not in my office. I was in Dimapur on that day. So that I'll come to later on, your lordship. So your lordship will see that in the charge sheet for the first time, the concept of DD entries came. Before that, no DD. They said they were at the initial stage when the initial no dates were given. Nothing. Only after a few days and this thing one has stated.
Which GD entry?
DD entry, your lordship, 6/8, this is 6/8/2018 and 17/8. It was on this basis of these two entries has been interpreted later on. I have been charge sheeted, your lordship. Yes.
Which two GD entry?
Your lordship will see 6/8/2018 and 17/8/2018. Here, your lordship, this is the end part. Beginning, your lordship, just after the incident, your lordship, a report was called from all these four PWs, your lordship, and the three PWs, your PW 2, 3, and 4, and there no dates were mentioned on 2000 incident, alleged incident of 3/8/2018, and the report is of 25/8/2018 and 28/2018. No dates were mentioned. Nothing of DD&T, nothing. Yes, your lordship.
I'm not getting it.
Yeah, what I'm
Originally, an FIR was lodged by
FIR before the FIR.
No,
before-
what I have understood
Yes, your lordship.
in connection with the earlier case, that originally the commander of the NCB, the
Narcotic,
narcotic cell,
uh,
lodged an FIR.
that was that.
That
No,
that was not
not
registered.
registered FIR. There's a Caesar memo also. Caesar memo, first Caesar.
Let me narrate what I have
Yes, your
understood.
lordship.
That was not registered, therefore you preferred a WPC criminal.
Yes, your lordship. You're absolutely correct.
In that FIR, the allegation was
Complaint. That was a complaint. FIR was not raised.
it was not registered.
Not registered.
The allegation was some contraband heroin was seized.
No, it is brown sugar, not heroin.
Brown sugar was seized.
Suspected brown sugar.
And you thereafter the allegation was made against you.
Yes, your lordship.
When that allegation was?
Allegation was made against subsequently when 25/8/2018 that at ADG Law and Order, he asked for the report from this officer PW2.
No, my query is
Yes.
this charge sheet is on the basis
Of
of
the
some
FIR 110/19/2018. That is subsequently. Before that, the reports were there. On the basis of the reports,
this charge sheet has been laid on the basis of
Caesar is 19, charge sheet is I'm sorry.
you answer my query.
Yes, sir.
This charge sheet has been laid on the basis of not on the FIR of the commander.
Yes.
The
FIR against me.
subse-
FIR against me.
Subsequent FIR
Yes,
has been
Your Honor.
filed. Which is the date?
FIR 2010.
Where is that FIR?
That FIR is there, Your Lordship. It is there. It is there, Your Lordship.
The date is 20?
2020
Yes.
10/2018, Your Lordship.
Who lost this FIR? 20?
2018, Your Lordship. That is here in this, Your Lordship. I will
Whom-
take Your Lordship to say. It is at. That is at Your Lordship. Just give you the page, Your Lordship. It is at page 114 and 115 of the paper book, 114. Your Lordship, prior to the lodging of that FIR, Your Lordship,
Okay, just saying.
Yeah.
Who lost this affair?
This was lodged by Your Lordship, one Tuluku Angavi DSP.
DSP,
Yeah, Lordship.
DSP claim.
Yes, DSP crimes. Yes, was there. Yes, was the referred, Your Lordship. And if Your Lordship will see this
And in this affair, what was the allegation made?
allegation, FIR is here, Your Lord, FIR, Your Lordship, this FIR will be.
It is it is in 114 and 15.
Yes, sir.
Only
114.
format of affair is. there.
Format, the FIR
Where
is
is the affair?
FIR will be in the other volume, Your Lordship. That
Where is-
FIR, that criminal petition 9, the 5 of the other, there the FIR. Yes. It will be WP also, WCC also is there. I just give me a minute.
No.
It is in
Wait.
WPC also.
Where is the affair?
I just give it.
Our Lordship, it's in page 71 of
Yes.
the criminal 5 of 2021.
That is also there, the writ petition also it is there.
71.
Yes, page 71 of
The
criminal
writ
petition 5.
71 of the writ petition, if you will see. It starts from 73 to 75, the writ petition, Your Lordship. P8. P8.
Okay, this is the affair.
Yes, Your Lordship.
What was the allegation?
Allegation just, allegation was, Your Lordship, just.
It is a small affair.
Yes, sir, one page, Your Lordship. Because that was a part of this document, Your Lordship, that's why I didn't.
According to this affair,
Yes, sir.
the logic complaint. The suspected brown sugar was seized from
Yes.
your official receipt.
Yes, Your Lordship. Here also no dates have been mentioned. When
And-
it was handed.
Okay, and on the basis of this affair, ultimately charge sheet was
Yes, Your
made.
Lordship. Your Lordship.
Now you submit.
Your Lordship, the prior to that, I have to point out 2-3 things because that regarding the date. If Your Lordship will see, there prior to that, there's a report called by before the seizure, first seizure member, the second seizure member. Your Lordship. A report was called by the ADG, which was submitted DGP later on, Your Lordship. If Your Lordship will see,
Which report you are?
Your Lordship, this report was sought by ADGP law and order, Your Lordship. That is, he has asked his officers to submit. One was annexure P3, Your Lordship,
Page
page 9900, Your Lordship.
of this criminal petition.
Yeah, no,
petition.
agreement, yes, sir. Annexure P3.
Page 99.
Yes, sir, 99. Here, Your Lordship will see.
No, what is this 99? This is a submission of detailed
Yes,
report
yes,
in
the report.
connection with.
Yes, sir. Why I'm pointing out, Your Lordship, here Your Lordship will see no dates have been mentioned here. Neither 6/8/2018 nor 17/8/2018 has been mentioned, Your Lordship. This is this one. This is by that commander PW4. This is by PW4, Your Lordship. Then, Your Lordship.
No, why are you mentioning about this?
Because of the dates. Because what I'm saying, 2018 after the incident, there are no dates somewhere. The dates came in that time of filing of charge sheet.
No, when the seizure was made, original.
See, 19.
19.
Yes, sir. 19/2018.
19/2018. And thereafter, on lodging of the affair by the commander, it was not registered.
No, that has not that is a separate
That
chapter,
is
Your
a-
Lordship. That is a
Then
separate chapter.
on,
Nothing happened in that.
then in 2010,
Ah,
2018,
18,
FIR was.
FIR was
registered.
lodged against me, Your Lordship.
Okay. In this reference, you are citing this report.
Yes, Your Lordship.
Now,
Report.
what is the purpose?
Report is because that 6/8/2018 and 17/8/2018 did not find mentioning any of this report, Your Lordship. That is my submission, Your Lordship.
Six, 8/2018.
And 17/8/2018.
What happened on these dates?
See, in the charge sheet, Your Lordship, I may, because then what happened here in the charge sheet for the first time, they said they have made their allegation, I didn't allow them to make DD. They came with a lateral story and the charge sheet on 6/8/2018 and 17/8/2018, DD entry was made. This is not, there is no evidence to that record because PW2 and PW3, they made section 161 and 164 statement also. There's no dates. They mentioned the date in 2019, not in 2018. The dates are mentioned. The dates came later on here. That is what I am to point out here. These dates 6/8/2018 and 17/8/2018 came at a much later stage. It has been incorporated because the same officer who cannot say about a date on the on 2018 came to know on 2019 about the dates. And 2022, they didn't say about in that 161 and 164 statements made by this accused, PW2 to PW5. They have mentioned that 6/8/2018, 2019 and 17, but no GD entries have been mentioned. So my humble submission is that the charge sheet which contains that it was the charge sheet has been based on entry made in GD entries nowhere to be found because the evidence PW2 and PW they didn't state anything on that. According to me, this GD entry was made subsequent to that before the filing of charge sheet. These dates. Because in the memorandum of charges of 18/12/2018 also, where disciplinary procedure, these dates are not mentioned. Memorandum of charges is also there here, Lordship will see. The dates are not mentioned. 18/12/2018. Memorandum of charges, these dates are not mentioned here, Lordship.
Now, what charge sheet mentions about these dates?
Yeah, charge sheet says.
Let us go to the charge sheet.
Yes, sir. Charge sheet. Charge sheet it's here, Your Lordship. That.
Where there is a mention about 6/8/2018.
Here, Your Lordship, I may point out one thing. First, there was a charge sheet was filed on 22/11/2018, 2021, Your Lordship, with a sanction order. Then subsequently, this was withdrawn and it was replaced by second charge sheet. This is what I am challenging, a second charge sheet. First charge sheet is not in record.
No,
So-
what is your submission? First charge sheet was laid on
22/11 first, 22/11/2008, 2021, Your Lordship.
but that is the date of charge sheet you have mentioned.
Yes, first charge sheet.
And when is the second charge
So
sheet?
the first charge that was withdrawn. Second charge is it was dated 14/3/2022 oblique 15/3/2022 and was submitted the code on 16/3/2022, Your Lordship. Second charge sheet. Here, Your Lordship was this is unknown. Section 170 doesn't permit that you take back that charge sheet, replace it with another charge sheet. So that all these things are gone into Your Lordship. That's why I'm saying this.
I may be allowed to indulge your lordship. Indulgence. Lordship, I pray that my learned friend has been taking so much time on the last 5 or 6 days. So Lordship, I pray that let his submission be brief and then I submitted and we concluded the matter today.
Okay. For
Because
5 to
your
6 days,
lordship
when did I
Yes,
argue?
and going round and round. He has to place before your court as to why the charge sheet.
He doesn't have to tell me what I have to argue.
And the other part is that
He
whether
doesn't
it
tell
is
me what I-
permissible or not.
Let her make submission.
Yes. So my prayer is that your lordship, he has been taking so much time.
Why? What is wrong with her?
No, we have to finish it.
Yeah, I'll finish
Yes,
it.
finish it today. So
I'm
your
going
lordship,
with
I pray that he finish by 3, so that I can.
it. She cannot dictate me what I should do.
No,
Why? How can she dictate me?
So, your lordship, he has been taking so much time of
What
this
to
court,
no more time.
so much time of this court. on the last
I have to
76
argue. You cannot
days,
stop me
your
from
lordship.
arguing. You take care of your own brief. Don't say what I have to argue, what I don't have
Please
to argue.
don't argue amongst
No,
yourselves.
Your Lordship,
Let
that's
us-
not fair, Your Lordship. Why she making comments on me? I have put on much more years than survey in the profession than her. I'm not a fool here.
Much time will you
I'll
require?
take this today. I'll try to finish it today. So
See,
Your
Your
Lordship,
Lordship,
She has to answer also.
yes,
yes, Your Lordship, so I pray that his submission should be limited till 3. Then
Okay.
after that, I'll submit. I will not take much
let
time,
her
Your
say I
Lordship.
need not argue the matter, she'll argue, finish it off.
Yes, then Your Lordship, in that case, let me out argue so that the matter becomes more clear.
Go ahead, go to argue. Why should
Let-
without petition arguing, she is trying to. Why she is wasting the time of the court like this?
Try to complete.
Yes, sir, at that time, because that disturbs the flow, Your Lordship.
Okay. Now, why
Yes.
are you referring to
Yes.
6/8/2018 and 28?
Yes, 17, that is, they said, on this date, I have taken the drugs from them.
To your residence?
Yes, Your Lordship.
Okay.
At that point of time, in the report which they
And
submitted,
your submission is, for the first time, they have mentioned these dates in the charge sheet?
charge sheet. No,
Because-
not. That their DD entry made, DD entry made was first time mentioned in this thing. And dates were mentioned in that 164 statement, PW2 and PW3. 164 statement at 2019. Not in 2000, no 2000, no dates are there.
Okay, proceed.
So, Your Lordship, just let me go step by step, Your Lordship. Yes, that I will take, Your Lordship, because what has happened, Your Lordship, first, there were 2 seizure lists now. I'm coming to the point here. Because if Your Lordship see in page 5 of the comparison, Your Lordship see, I have narrated the thing.
Where?
Now-
Where?
In the written submission, Your Lordship.
Okay.
Page 5, Your Lordship see, these are the things which I'll be doing it also. One is 2 seizure lists dated 3/8/2018 and 1/9/2018, Your Lordship. Then second is 3 sanctions order dated 39/2001, so and so. This is not a part of the records of, they have deleted. Then thereafter sanction order 73/2000 and 73/2. Your Lordship, with the first sanction order, they filed the first charge sheet. They withdrew it, then again took second sanction order. Your Lordship. Then 2 charge sheet dated 22/11/2009, 14/3/2000, so and so, filed by the IO. Then interpretation section 173 of the CRTA. Then PW2 to statement under section 161 and 64 of the CRPC. Then non-compliance of provision of CRPC, Police Act, so and so, Your Lordship.
No, let us once go through the
Yeah.
charge sheet which
Yes, Your Lordship. Yeah.
you are impugning.
Yes, Your Lordship. Let us-
Where is that charge sheet?
Charge sheet is there, Your Lordship. Charge sheet is in my petty. It starts at, Your Lordship, page 152, Your Lordship, 152. Uh,
150,
152, Your Lordship.
153.
153 is a type copy, Your Lordship. It starts from 152, Your Lordship. Your Lordship, forwarding of the charge sheet, so and so,
This is charge sheet dated
16 March 2022, Your Lordship.
16/3/2022.
Before that, I'll show you another letter, if Your Lordship will permit me, Your Lordship. That is also here. That is what I was saying, Your Lordship. Yes, Your Lordship. That is, Your Lordship will see. Page 143, 144, Your Lordship. 143, 144.
Let us go through your prayer portion of the,
No, Your Lordship, this is very important. Your Lordship.
before
Yes,
the
Your Lordship.
prayer
Yeah.
portion of the,
Yes, yes.
what is your relief which you are
Yes, sir.
seeking?
Prayer process starts at page 90, Your Lordship.
No, specifically come to the.
Yes, to quash the second charge sheet dated so and so filed by the court so and so Nagaland Kohima on
Page?
page 90.
Okay, so your prayer is to quash the
Yes,
second charge sheet.
And
Oh,
criminal proceeding also, two prayers are there.
okay. Okay.
Yes. Then I take your lordship to page 143, your lordship. Page 23/11/2021, your lordship. This to the principal, forwarding your charge sheet original with all the so and so. In connection with the above cited, I have the honor to forward here charge sheet along with all relevant inputs in original, submitted to ITS so and so, submitted to so. Here this first charge sheet was filed on this date, your lordship.
143 is the first charge sheet.
Yes, first charge sheet, this is a covering letter, charge sheet is not there. They have removed the thing. Then next page, the endorsement, they have taken it on that, this endorsement from the, this thing, no, the records. Page 144, charge sheet and all relevant including original says so and so taken back. They have taken it back. It was submitted on so and so, it was taken back on 15/12/2021.
Where is that endorse
Your lordship.
regarding taking back of the charge sheet?
Yes, 15/12/2000. That is
Page.
that has been dealt in that IA number 5 in the other matter, your lordship. Regarding taking back of charge sheet, we asked for an inquiry how this has been taken back. That is in that other matter, your lordship.
Okay, no, you may submit.
Yes.
That taking back is relevant in this case also.
Yes, sir. Yes, sir. Very
On
right.
which date it was taken?
It was
back?
15/12. That they have admitted this. 15/12. That is, I have that letter is there. Here. IA number is IA number 5, your lordship. 5. I have filed for that only. IA number 5 in that criminal petition 5 also. You know. That is just.
At the time of taking back of this charge sheet.
Yes, sir. 15/12. They have admitted that fact.
With the.
No, Lordship,
with
we
the
have not
court.
admitted that.
Yes. Huh?
We have not admitted that charge sheet
It is
was.
there in the affidavit. You have taken it. I can show it from the affidavit. They have
Okay,
taken
you-
it back.
You make your submission.
Yes.
I'll hear you later on.
Lordship.
Yeah, 15/12, your lordship. 15/12, they have taken it back, your lordship. They have said it there in the affidavit.
Okay. Thereafter,
Thereafter, they again went for subsequent sanction order. Suppressing this fact that there is a first
no,
sanction.
this charge sheet was taken back with the leave of the
No,
court.
nothing. They have taken it on the.
Then on what basis you are saying that?
Yes, it is there. That's on record.
It is on
It
record.
is on record, your lordship.
Where, show me.
In
From
fact,
where?
they have just, give me a minute, I'll show them there. Stated here. I have made a statement, they have.
No, on what basis you are saying that it was taken back?
Yes, it was taken, how the second charge has come on certain that.
No, that is okay. But on 15/12.
Yes, they have taken it back from the custody of the court. The record will show. The case record will show.
Show me that I want to understand.
Yes, sir. 15/12, they have to, 15/12, they have to, I dig with that date. That's a record. Record of the case, it is there. They have taken it back from, they have endorsed for the this thing, your lordship.
Where is that endorsement?
It is the file, I think. The file.
You have to show it to the court.
Yes, I just,
When you are making a statement
Yes,
that
sir.
they have taken, on some basis you are making that statement.
yes, your lordship.
I want to see that basis.
Yes, yes. Your lordship will see page IA number 9 of 2000, annexure is there. Your lordship will see.
I number 9.
9 of in criminal petition 5 of 2021.
Which annexure?
Annexure P20 is that P20 and P21 they have taken it back.
Page?
Page, if you lordship will see 18 starts with the letter with the following this thing. 19 is sorry, this is page 20 is that this thing they have received. Page 21, if you lordship see. Page 22, sorry, annexure P21, I have got a type copy also. Last page.
What is this? This is,
That court memo is there that they have taken it, this one. This is here. Here, if your endorsement is there, your lordship.
no, what is this? This is a
Yes,
photocopy of what? Register or?
yes, register. It is in the file, your lordship. Yes. Because we went to inquire about we went to collect the charge sheet. Then they said charge sheet has been taken away in the month of February, your lordship. CS, your lordship, see, date 22/11 as for so and so. CS returned to IO. So Lordship, CS returned to IO. How can they can return the IO?
CS returned to IO.
IO on 15/12/2021. This is there, Your Lordship. That's why these two IAs are filed, Your Lordship.
What is this page? This
Sure.
page is from
Which one?
where it
That is from the register, the court register.
court register.
Yes, it is there. It will be there in the file. The record will be there. They
No,
have not denied this thing, in fact, also in the counter also. They have filed a reply also. If they have not replied, denied it also.
no, you are relying on your submission
Yes.
on the basis of this annexure. So you have to make clear submission. What is this? When I am asking, is it a part of record?
Yes,
Is
sir.
it a register? If it is a register,
Yes.
what register it is?
Yes, I think the court register.
It is, is it available with the record?
Yes, it is there. It will be there. In fact, if you see the affidavit also, they have admitted it. The reply in IA number 9 of 2000, the reply, if you lordship see,
Reply affidavit,
reply affidavit.
where
Para 10, if you saw that you take so and so applicant denied country, there are there is no two charge sheet as the alleged in the petition so and so violation section 170. So Kohima to verify in the deficit. They said the public prosecutor verify the charge sheet if there is any deficit present as well as charging section before the same is put up a trial court. According to the public prosecutor on waiting of the charge sheet found certain ratification made and therefore my lord has got it. Page 4. Concise memo dated 15/12/2021. The charge sheet was returned to IO and the case diary for now. How can it be returned to IO?
okay.
This is they have admitted it here also. This fact.
In para,
Para 10. They have also given. They have,
Lordship, may I kindly read the full paragraph?
yes, I have read the full.
Paragraph.
It's better. It is a privacy under case diary and we are even
it's
charged.
okay. You note down his.
Yes, but Lordship, the full paragraph, let my another friend read it, not the half
How?
part.
No, you make your, he's saying that there is an admission. If it
That
is
is
not,
not an admission, so the full paragraph will explain everything.
no, you reply later on when your chance comes.
She's getting over it.
Okay, okay.
That- if
And
I-
your
I
your
did that.
submission is that in.
I
para
read
10 of-
that. See, let us be satisfied, Your Lordship. The by consent of 15, the charge sheet was returned to the IO, the case further necessary. Hence, such short term for rectification of the charge sheet are permissible as per law laid down by Supreme Court. Further, under section 170, the petitioner cannot be privy to contents of case diary or that matter even charge sheet has not been taken cognizance by the court. The petitioner divided by. How can it be? Charge sheet once it is filed to the, it becomes the custody of the court. They cannot take it back without the permission of the court.
Okay,
And maximum, if they can go for supplementary charge sheet. So this charge sheet was completely removed from the file, Your Lordship. So now, Your Lordship want me to read the charge sheet. No, I just
no, no. I just, now, now your, one of the plea is that
Yes,
this charge sheet which you are challenging.
it cannot send
is the
the
second charge sheet.
yes,
Without the, it was taken back
Ah.
without any order from the
Yes.
court after.
and
And-
it is not a section 73, 173(8) charge sheet also. It's not a supplementary charge sheet also.
Okay,
Because 172 category state that you cannot, is very clear on that point, Your Lord. I'll address those arguments, Your
okay,
Lordship.
okay.
Because
Okay, now let us,
let us go systematic stage by stage. I'll come to charge sheet later.
so in your submission is that in their affidavit on reply, in reply,
They have admitted the fact.
they
They have
have
taken back
admitted
the
in
first charge.
para 10.
Yes.
She will response to it.
Yes, yes. That is.
Yes, now proceed.
Your Lordship. First, I am coming to seizure list, Your Lordship. Go ahead. There are two seizure lists, 3/8/2018, 1/9/2018, Your Lordship. Same material, Your Lordship.
In this case.
Yes, in this case, Your Lordship.
Seizure list first is.
First
3/8,
is 3/8/2000
second-
and 1/9/2018, where they have taken back from me items, Your Lordship.
Where is 3/8/2018.
3/2018 is there already. It is annexure P1 here. Sorry, annexure P2. Yes, it is here. Here also.
Page.
I just give me. I don't give. It is at page 9, annexure P2, page 97 to 98 here also. Annexure P2. Annexure P2. And the second one, your lordship will see page 111 to 112. Two serial list, your lordship.
But this first Caesar list was not in connection with the FIR lodged against you.
No, but the item,
Or
same item.
contrabands.
contraband, same contraband. It is related to contraband, not the FIR. Contraband, if your lordship see, if your lordship.
First Caesar list was before the FIR against you.
Yes, your lordship.
Okay.
If your lordship see page 98, your lordship, page 98, if your lordship see page 98, suspected bounces approximately 6.9, so 11 packets. Is there? My lord has got it.
Yes.
Para 13.
Yes.
Then again here also same thing. It is also same. If your lordship will para 10, 11 packets of suspected or 9 packets, your lordship will see para second season, same item.
Second Caesar list is that
Page
page?
111, your lordship. Second season list, your lordship. And if your lordship will see here, this season was done by PW2, who is also a suspected accused in the FIR, in the investigation, your lordship. Narola Sophie, she is PW2, your lordship. She is also one of the suspected accused in the matter, your lordship. It is the dereliction duty of her only, not registering the FIR, your lordship. And if your lordship will see, witness number 1, PW3, he is in charge of he is also one of the suspected accused, your lordship. So this Caesar memo, your lordship will be, it's not, there's no independent witness also for this Caesar also, second Caesar, your lordship.
Second Caesar was by the accused in which case? In the second case?
Yeah. Second
In
case.
the FIR?
FIR, there's only one in that FIR. They have made, in the investigation, they have also made suspected accused also.
Okay.
And they have, in the charge sheet, they have acquitted them.
But in the FIR,
The names are not there.
names were not there.
As a only names, no
So
names.
on what basis you are saying that?
Yeah, in the charge sheet, charge sheet is there. I just pointed that para, just.
That,
I just read that para. Just give me a minute.
but for lack of evidence, they were not.
Lack of evidence, there's no evidence against me also. Yeah, that's it. Your lordship will see, I just read that portion. Your lordship. It is at page 165, the charge sheet.
Okay.
If you are during the course of investigation, it was found that there were no sufficient evidence to prosecute so and then SP and and you they are therefore dropped from the charge of the present case. So according to me, these are the people who are involved, your lordship. So here, even the Caesar memo is by them, your lordship. And there can be second seizure of the thing because the property has not gone out of the custody. They have said it was kept in my custody, your lordship. Keeping in the custody and going out of the thing is different, your lordship. They said, I have asked for the thing, allegation, and to keep it in custody of mine, your lordship. So keeping in custody cannot constitute such an offense, your lordship, because it is still in the hand of the, there can be a seizure, second seizure will come into force only when the material has gone out of the control of the police forces. Someone has stolen someone, then the second seizure, concept second seizure comes. here it cannot be done because the first seizure is on. The moment the first seizure comes, the whole problem crops up. So they suffer. That's why they didn't go into first seizure at all. This thing because the first complaint and first seizure was not taken into consideration by the investigation because the moment that the whole criminal case falls to the ground, Your Lordship. No legs to stand, Your Lordship. So
Now this first seizure which you have annexed as P2.
Yes,
annexure
sir.
P2,
yes, sir.
whether it forms part of this charge sheet.
Yes, yes. It
They
is
have
there.
annexed it.
Yes, yes. It is. I just give you. It is in. It is in D. I've given. It is in.
No,
Your Lordship.
whether they have, I have made any narration
Nothing. D5.
that
Compilation D5. Compilation D5. It is there, Your Lordship. It is there. No, it is not there. It is a record. Charge sheet record. I'll because that Your Lordship won't be able to trace out. What I'll do, if Your Lordship, I'll make a photocopy of this because I've indexed
but your submission is that this first seizure list is
in
the-
existence. Your Lordship, if the drugs and how the drugs has come to the position of the.
that I have understood.
Yes.
But whether while filing charge sheet against you,
Yes, Your Lordship.
they have mentioned that the drugs were first seized on
Nothing.
3/8.
Nothing.
Lordship, that is in
Nothing.
page 516. That is mentioned in page
Your Lordship,
156.
if she start interpreting, how can I do it? Every day she pokes her.
No, you don't.
No, Your Lordship, this is not fair. I am waiting for shield and derail the whole thing. So
I'm
this
not submitting,
is
Your
bound to
Lordship,
take
I'm
time.
just
It is
testing.
bound interpreting like that.
It's in page
Why
156.
she is so excited of the matter? I don't understand.
No,
Yeah.
okay, you answer my query.
Yes, sir. It is
The-
part of D5.
The charge sheet which is filed against you
Yes, Your Lordship.
mentions about the seizure list which you have annexed
Yes,
at P
yes.
111. My query is whether
P,
whether it
P2
also
or
mentions about
P2, Your
P2.
Lordship. It has not mentioned in the church, nothing.
So from where you got this charge sheet,
Which one?
this first seizure list?
First, see, they have signed it. Yeah, they have given it. I asked, they have given it this thing. That is part of the record.
They have given
Yes.
along with the charge sheet.
No, they have earlier also I got it because they have given me because when I asked for the paper, they gave these papers. So that's why I filed the first FIR. But that criminal petition 5 of 2000 because at that time they handed over me. I asked for a copy. They sent me the copy. So this is part of
But
the.
part of the, no, I want to make
Yes, sir.
myself clear.
Yes,
You said there were two charge sheets.
yes, sir.
First, earlier one charge sheet was laid
Yes,
and on
Taken back.
15/12 it was taken back.
yes, sir.
And then after rectification, they have again.
No,
filed-
no, I'm not saying rectification because they
They have, okay.
after that
They-
then again sanction order was taken.
Now, the second charge sheet which was laid on
Mm.
15th.
Yes, 16/12.
16/3/20.
yes, sir.
Whether with that charge sheet, this first seizure list was also annexed.
No, they have put it, but nothing discussed. They have only D5 part of the record. Nothing is in a charge sheet about that. No discussion at all.
No discussion about
Nothing.
it. It is your submission that when a contraband has been seized once,
Yes, sir.
there cannot be a second.
Second
seizure.
seizure. Yes, yeah.
Okay.
That is a
Okay.
that is a submission, Your Lordship. There can be second seizure of the same item again. Because and here Your Lordship, the problem is how the drugs has come to the custody of the police. That is not that there's a missing link.
Okay, from whom it was
How it has originated because
originally it was.
it was there, nothing is there. Originating of the drugs to the from where it has come to the police narcotic cell, that is not been there is no link on that, Your Lordship. So keeping in custody from where the drugs has come, nothing, there's no investigation on that part. How the drugs has come, not the drug peddlers have been case has been resolved. Rather, the drug peddlers have been prosecution witness against my disciplinary proceeding. These two drug peddlers have been made prosecution witness in the DP. And after
Then
both
in the first charge sheet,
yes, sir.
is it mentioned from whom it was seized?
Which one? Your Lordship.
First seizure list.
Further say, yes, Your Lordship. It is there.
Well,
First seizure, it is page, it is first.
Rahul Kharel,
Rahul Khare, yes, Your Lordship.
Rahul Kharel and
Page.
Konyak.
Yes, Your Lordship.
No,
Sorry, Your Lordship. It is there, Your Lordship. I'll give you the page. It is, they are the person, and they have been made, prosecution, it is against me in the DP. Disciplinary proceeding.
Okay, for the time,
Yes, sir.
for some time, let us forget about DP.
Yes, sir. No, I just,
The second charge sheet, what is the status of Rahul Kharel?
nothing.
They have not been made
Nothing,
accused.
they have not gone into it. Rahul Kharel, they are nothing on that.
No mention about
Nothing.
Rahul Kharel
Nothing,
and Benu Khan.
nothing.
First one is Rahul Kharel. and-
Then is some Lamba, I think. Yes.
Okay,
Rahul Khare, I just, Deepak Lamba, Rahul Khare. They are not part of the second charge sheet also.
your submission is that second charge sheet does not mentions about the original seizure,
Yes, sir.
from where it was
yeah,
originally
that is-
seized
that
and
is-
who
that
were
is
the
my-
accused persons.
Yes, sir. And from fraud source, they have got this drug to be given to me.
Okay,
That has not been investigated at all. Then if your lordship will say this thing, if your lordship takes 173, very clear. Section 173, your lordship. Section 173, your lordship.
yes.
Every investigation under shall be completed without unnecessary. One is not related, your lordship. Two is very important. As soon as it is completed, the officer in charge of the police station shall forward the magistrate empowered to take cognizance of the offence on a police report, in a form prescribed stating so and so. This is there. Then your lordship will see these are the things whether offence is additional or not concerned. Then I'm coming to 8. Nothing in this section shall be deemed to preclude further investigation in respect of any offence after report on subsection 2 has been forwarded to a magistrate, and where upon such the officer in charge of the police station obtains further oral or documentary, he shall forward it to the magistrate and a further report or reports regarding such evidence in the form of prescribed provision setting. Subsection 2 to 6 shall be as per may be applied to release such report or reports as they relation to report for under section. So here 73, some new material has been discovered, all these things, then they go for supplementary search. There also the Supreme Court judgments are there, how on what basis the supplementary charge sheet can be filed here. I have given the judgments also. Because here if you will see that even Lalita Kumari judgment also, I gave 5-6 judgment here. I just deal with the judgments also. Paras, I just deal with the paras here. Because I have given all these paragraphs, your lordship will see this. Yes. Excellent. Just give me a minute. Excellent. 2014, that your lordship, that 2 SCC, your lordship, that is a constitution where that also dealt with the same issue, your lordship. That we have referred it also, the Lalita Kumar Snatcher. Excellent. Lalita Kumar judgment, your lordship, para 77. Yes. Your Lalita Kumar constitution bench judgment, para 70. That I referred to judgment in that earlier material, para
Yes,
77.
what is the citation of
2014. I have given all the citations are there in the detailed submission. Citation para numbers are there. 2014 2 SCC page 1. And if your lordship goes to page Para 77, Your Lordship.
What it says?
In Ramlal Narang's, the code is under so and so, this also I have referred here also. Under CRPC 18, whenever an officer in charge, my lord has got it. Page 45. Sorry, I'm sorry.
Lalita Kumari's judgment.
Yes, Lalita Kumari's.
Her judgment.
আগৰ হেৰিটো আছে হাইকোৰ্ট ৰিটৰ হেৰিটো কম্পালচন আছে ৰিটৰ কম্পালচন আছে জাজমেণ্টৰ ৰিটৰ কম্পালচন জাজমেণ্ট আছে দুটা জাজমেণ্ট আছে ললিতা কুমাৰী আছে
মুখ দিয়ক দেখা মুখ দিয়ক
in my lord has got it
yes
page 45 para 77
page
for page 45 para 77 in Ramlang Narang the court has under so and so has held under CRPC 18 whenever an officer in charge of a police station received information relating to commission of a cognizable offence he was required to enter substance thereof in a book kept by him for the purpose in the prescribed section 1 CRP section 150 invested the police with the power to so and so your lordship I'm not skipping this and I'm going later on your lordship next page your lordship section 173(1) this your lordship it says he is required to complete the investigation.
where are you reading at
Para 77. If your lordship section 150 CRPC after that I am reading if your lordship. Para 77. He was required to complete the investigation with unnecessary delay and as soon as he completed forward to the magistrate empowered to take cognizance of the offence upon a police report, a report in the prescribed form setting for the nature of information received and a person who appeared according to circumstances of the case. Section 173(1). He was required to state.
Mota judgment আছে Lalita no you read Lalita Kumari's also
Judgment to assert that.
no you read I'll listen I'll hear you
I'm sorry also. He was also required to state whether the
what point you want to emphasize
173(8) that there cannot be a second charge sheet. This on they cannot take it back and file a second charge sheet. This 173(8) specific one. They cannot because new things has to come to the existence. All those things are there.
so your submission is that if there is something new they can file
Yes,
supplementary
they have to apply to the court. Apply to the court has to, then they can go for second investigation.
okay but
Not otherwise.
in the instant case
Nothing has been. They have taken it back.
without leave of the court
Without leave, they have taken
back.
it, and that has been totally that they have not filed the record of the first charge sheet. Is not there.
okay
They removed the first charge sheet. Even your lordship, first sanction order regarding the first charge, that's also not there in the record. They were in respect of first charge sheet, 39/2020 when the first sanction was taken, and sanction was given under PC Act, not under IPC. That also on the record, your lordship. So your lordship, this 173(8) is there. Then your lordship, the latest judgment under apex code is there. That's the para 16 of this judgment, your lordship. It is Kishan Lal judgment, your lordship.
what is the citation
2009, sorry, 2009, 7 SCC 685. It is at para 16, your lordship.
Kishan Lal
Kishan Lal versus Dharmendra Bafana and another.
relevant paragraph is
Para 16. Then I have referred in the literature. May I read it, your lordship?
what it says
The investigator may exercise his
no what point you want to emphasize
that 170, how on what basis 170, how can they go for further investigation?
okay and in this case it was not followed
Not for.
okay
Here, if you may I read it? If the one para only. The investigator may exercise his statutory power of further investigation in several situations, as for example, when new facts come to the notice, when certain aspect of matter has not been considered by him, and he found that further investigation is necessary to be carried out from a different angle, keeping in the fact that a new and further matter came to his notice. Apart from the aforementioned grounds, the learned magistrate or a superior can direct further investigation if the investigation is found to be tainted or otherwise unfair, otherwise the question, however, is to whether the case is the nature direction further, then it would be necessary. So your lordship, he cannot do on his own. It is the satisfaction of the court. New matters, he has to show new matters have come, this has not been investigated, then he can go for. So 173, they cannot go for. That's filing of a second charge sheet, Your Lordship. The judgment I have already referred, Your Lordship. This judgment if Your Lordship see page 11 of the written submission, Your Lordship. Page 11 written submission, Your Lordship.
Yes.
The judgments are there already. I cited, Your Lordship. This
Okay.
all the paragraphs I have given. I need not take your trouble, Your Lordship.
Okay.
The judgments are all given, Your Lordship. Then I come to a sanction order also. Your sanction order is very important. Your Lordship, in this matter, there are 3 sanction orders. Page 8, Your Lordship, see, sanction order. I have, Your Lordship will see in this petition, I have annexed the first sanction order also. Your Lordship, that is at first sanction order, if Your Lordship, page 141, 142 paper, Your Lordship. 141, 142 of the paper, Your Lordship.
Yes. 141 is the
Yes, first sanction. This is not a part of the case record now. 39/2021, Your Lordship.
it is not in record.
Not at the record.
Okay.
This prosecution under section, they have given under section 19 of PC Act, Your Lordship. If Your Lordship, turn to next page, Your Lordship, 142. Whereas I, Sri Abhijit Sinha, IAS Principal Secretary Home, being the authority to remove so and so, then after fully and carefully examining the case record and material before me with regard to said allegation, and after due discussion with the investigating officer and on proper application of mine, I am satisfied and come to the opinion deciding to have committed offence under section 5 and 11 so and so 21C of the NDPS Act, section 20 put it under section 7A prevention of corruption, and as such should be prosecuted at court in the said. Now therefore I wish to principle accord sanction under required section 19(1)(c). Prevention of
Now the
corruption.
prosecution is not relying on this sanction order.
That they cannot do it. How can they do it? They, on the basis of this first charge sheet was fine. This is missing. The first charge sheet is also missing, Your Lordship. On the basis of this sanction only, the first charge sheet on 22/11, the first charge sheet at 22/11/2021 was filed, Your Lordship. Then if Your Lordship will see page 145.
Yes.
Page 1, annexure P16. This is letter 4/3/2022, Your Lordship will see. He again said, prior to accord fresh sanction under section 100 so and so, amendment and 91 prosecutor petition. If Your Lordship will see, please refer to the office memorandums at 29 and 27 so and so with regard to request for according prosecution under Prevention of Corruption Amendment Act to prosecute the accused so and so, and then IGP. Accordingly, sanction has been issued under section amendment and so and so. Charge sheet has been submitted on 22. Yes, here they have admitted 22/11/2001, the first charge sheet. And after completing investigation, however, concise memo dated 15/12 issued by so and so learned publication with observation for further necessary action. In this connection with the above prosecution sanction issued, it is brought to your kind notice the appropriate section that can be invoked in so and so. It's under section 7A2 and so and so, prevention of corruption, 490 so and so years. It is requested, please accord fresh sanction as so and so. Your Lordship, same materials. Now he doesn't refer to the first sanction order here. 39/2000, he issued a set that with sanction should
No,
go.
this is a letter written by the DIG
Yes,
to
to
Home
the Home
Commission.
Commissioner. That the sanction order.
Who is this DIG?
DIG
He's not the IO.
he's not the IO. He has written it. And again, sanction, second and third sanction also given.
From where you got this document?
This is their document. It's there.
No, where it is available?
It is
There
available.
must be some source.
Source is
Is
there.
it on record on?
This one will be record. It should be on record. This should be record. Let me check up here for the record number.
This is a prayer for issuing.
Yes, sir.
Second
And they have
sanction.
issued also. That's, I just,
Okay.
give me a minute, I'll just point out. It is there. Just give me a minute. Thank you.
Okay, we'll take it on its face value, that it is a letter seeking second
Yes, and it is
sanction.
given also, it is given
Then-
also.
Then where is the second sanction?
Yes, it's there, it is next page, if you also see. Here. Next page, if you also will see, page 146 here, this, if you 147. Same officer,
147.
yes, but
That's
one
the
forty
second sanction order.
second and third, two sanction orders there.
Page 147 is,
This prosecution sanction section 91 say amendment X so and so. If you will see, again, same sections are involved. Here, if you will see. Here, page 149, you will see.
second sanction order dated 7/3.
Yeah. 7/3/2022,
22.
your lordship.
Okay.
If you also see now, para one, page 149, now therefore visit Sina so and so 19(1)(c), prosecution Richard into so and so, punishment section so and so, section so and so, and in their office. So your lordship, again a fresh sanction has been given. So there is no reference of first sanction order at all, even the officer also. He should have cancelled the first, that's no cancel, nothing, that person they suppressed it. The second sanction order, then there's third sanction order also again, 190, again another one, next page, 150. This is again 197, 197 was refused earlier. 39,000.
Why this 150?
Yeah, 150, another sanction order, 7 March 2022.
With regard to same petition.
190, yes, same petty, same. He has given sanction on 197, your lordship. So your lordship, now issue is, how can they issue sanction order like this?
No, but what the requirement of law is that there should be a sanction order.
Yes, sanction. But
Whether it is first order or
no,
second
you're
order.
not fast, you cannot, sanction is a very technical, he should not play it lightly also. You cannot, for one case, you cannot go on issue sanction order. One sanction was there, you file the charge sheet, then you suppress that fact, got second sanction order and third sanction order, and file the second charge sheet. If it is supplementary charge sheet, then why the question of sanction there, your lordship? If it was second charge sheet 173(8), then the question of sanction doesn't come in, but it's not so. This clearly shows even the sanction orders are also bad. First sanction was there, okay, fine. You have applied your mind and give me sanction order one section, section 9.
Assuming there is a defect in the first sanction,
Your lordship.
then can it be rectified?
But they have not stated this, there's no record there. There's no stated, they have not stated. They should have, what they have said, if they said our first sanction was wrong, then I will supplementing, we are replacing by this sanction. We have not said that. The letter, they're totally silent on the first sanction order. So that they cannot do, your lordship. Because sanction order is the officer concerned, examine all the materials, discuss everything, then they issue a sanction order. It's not a child play that you go and issue sanction order after one after another.
And these sanction orders were in the case record, where along with the charge sheet.
It is a charge sheet at all. Is there?
These were submitted.
Yes, first charge sheet was missing, first sanction order and this thing missing, but this is there. I just give you the page number, it is there. There, if you want to see, it is.
Okay.
It will be-
Now, what is your submission that there cannot be 3 sanction orders?
Yes, your lordship. Here also they have state of sanction. Just give me a minute. This very voluminous sanction order is there, I think. Your Lordship, is it complaint D18? The sanction of 4/3/2022, all these letters are there, Your Lordship. D18 compilation, Your Lordship. D18 of the charge sheet record, Your Lordship. D18, it is there.
Okay,
These are all part of the record, Your Lordship.
now. Yes, proceed.
Yeah, Lordship. Then this, for this actually I moved to the IAS. Also, Your Lordship, for this 173 SH. So now, Your Lordship, I've covered this thing. Then I come to the statement of PW2 to PW5, Your Lordship. Because what has happened, PW2 to PW5, they made statement of section 161 also. And thereafter, these people made a section under section 164 CRPC also, Your Lordship.
Okay,
Now, so far, PW2 and PW3, they are also co-accused in the matter. So there will be a confession there. It will be a confession in nature, but the confession is totally exculpatory in nature. Nothing has been implicated on them. So this confession is barred by section 30 of the Evidence Act. Then so far, PW4 and PW5 is concerned, they are not accused. So their statement is under 164(5). And their Supreme Court judgment is there to that effect. Their evidence is very low. PW4 and PW5. PW4 is the commander of the narcotic, Kuzuma, who has seized the material initially, Your Lordship. And PW5 is another constable. Your Lordship. They made, now what has happened, Your Lordship? On the basis of section 161 statement cannot be used for the purpose. So they went for 164 statement. Making the basis 164, they implicate the petitioner in the whole episode, Your Lordship. That they cannot do it, Your Lordship. Because there is a lever, because if Your Lordship will see section 164, even the statement under 164 taken is violative on 164 too, because that.
no, what is your submission?
Your Lordship, here what happened? PW 2, 3, 4, and 5.
Their statements,
They made section 161 statements.
okay.
Out of these 4, PW2 and PW3 are
Your submission is that they are co-accused.
co-accused.
Therefore,
No,
they
not all. PW2 and 3.
two,
in terms of
two
the-
and 3 are co-accused, therefore, their statement are in the nature of exculpatory confession.
Exculpatory. The statements show that totally. Statement is totally there. They're putting on they are clean sheet.
And therefore, it is barred by section
30 of the Evidence Act.
Okay. And
Then
uh,
the other 2, they come under 164(5). Because there is a statement, there cannot be confession. It's statements only. And Your Lordship knows that all confession are statement, or are statement, but all statements are not confession. That the principle is there. Your Lordship knows about that. I'm not troubled on that. So, in that view of the matter, Your Lordship, if Your Lordship see the whole charge sheet, I just completed. It is totally based on these statements, that 164 statement that they have made against me, and I have they framed the charges against me. So that they cannot do it. Because even a confessional statement which is recorded, that doesn't suffice 164(2).
no, but if there is some material against you,
There's no, but or
164,
yes,
the statement of section PW4 and PW5,
yes, sir.
they are not co-accused.
They are not co-accused, but their statement is 164(5).
Maybe.
But that's
Their
not
evidentiary value may
evidence
be,
very less.
Yes.
Judgment that AR
but there is no bar in framing charges.
No, Your Lordship, there's the evidence, because on that basis you cannot hold me guilty. Even on that basis.
But can that be considered at
Yes,
this
yes,
stage,
yeah,
while
164, I just showed that judgment is there. Supreme Court
in a
judgment.
prayer for quashing of the charge
Yes,
sheet?
yes, it can be done, Your Lordship. Because if that is not made, not Maintainable, how can, why not, Your Lordship? That is year 1960 Supreme Court 480, Your Lordship,
What it says?
para 14.
AR 19,
60. It says, Your Lordship,
page number?
page 490, Your Lordship,
What it says?
paragraph 13 and 14, Your Lordship. The additional just so and so, he said he,
Now, what is the finding observation of the court? Even if you don't read it, you
Yes, sir.
can,
that they said statement on the section is not substantive evidence. They said that 164.5, Your Lordship. It can be used only to corroborate and contradict that witness, Your Lordship,
yes.
not beyond that. So now that cannot be a basis of the this thing, Your Lordship. That cannot be the basis of charging me in this, Your Lordship.
No, but the trial has not yet commenced.
The question.
When they will come, they will depose before you.
No, that is separate thing. Your Lordship, the question is, can you hold an investigation on the basis of these statements? Can you frame a charge on that without any evidence? These are all oral things. You are stating orally 161 statement, then you convert it to 164. Is it what they have done, Your Lordship? They first made the section 161 statement. Then subsequently, these people made that or the same statement on 164. Is it permissible, Your Lordship? Is it permissible?
No, I have not understood your submission.
Your Lordship,
Suppose there is oral evidence.
yes,
There is no documentary
yes.
evidence. Then whether charges cannot be framed
No,
on the
that
basis of oral
is-
evidence.
question- Oral evidence has to be reliable evidence, not one.
That will be considered
No, Your
during
Lordship.
trial.
No, question is, you have to see the legal position also. 161 statement is there. 161 statement on the basis of 161 state police before the police. Now, to make it more, they converted in 164, same materials.
Maybe.
And PW 2 and 3, there's a exculpatory, they are co-accused exculpatory. And PW 4 and 5 has not put much offense on that thing, they what their statement. So these are all tutored thing, everything is tutored, you can make it everything else.
No, but for that you will get an opportunity
No.
in while cross-examining.
But question is when the record is showing, speaking for itself. Record is speaking for itself, Your Lordship. Can you convert a section 161 statement to 164? 164 purpose of 164 is confession or anything. Your Lordship. Let us read 164, Your Lordship. It is not said section 164, Your Lordship.
No, I am not getting your submission.
Your Lordship,
What is your submission?
my
That
submission is, Your Lordship, these people have made statement on section
161.
CRP.
Is there any bar that their 164 statement may not be recorded?
The question is, there is no bar, but question is, can that whole statement be converted in 164?
Fresh statement have to be
But
recorded.
the procedure is laid down in 164. That's why I want to read 164, Your Lordship, for a continuous, Your Lordship. 164, if Your Lordship will see, recording of confessional statement. Any matrimonial magistrate, my Lord has got it once. CRPC, Your Lordship. My Lord has got it. CRPC.
That is not a confessional statement. They are not confessing anything.
No, I'm just two are there. Any matrimonial magistrate or judicial magistrate may, whether or not he has the jurisdiction in the case, record any confession or statement made by him in the course of an investigation under Section chapter or under any other law for the time being in force or any time afterwards before the commencement of inquiry or trial. Provided that any confession statement made under subsection may be also be recorded, or you see it is not here. Provided that no confession shall be recorded by a police officer on whom any power of a magistrate has been conferred, so and so. 2. The magistrate shall, before recording any such confession, explain to the person making that he is not bound to make a confession, and that if he does not, though it may be used as evidence against him, and the magistrate shall not record any such confession unless upon questioning the person making that he has reason to believe as being voluntary. Your Lordship, section 164(2) has not been complied at all. So see the confession said they have not been complied.
No, this is your submission that it is confessional statement.
Sure.
But prosecution is stating that this is not confessional statement because they have not made any implication against
No,
themselves.
prosecution is not saying that. It's I am saying.
Yes,
Prosecution not
they
saying.
have cited them as
No,
prosecution
prosecution said
witnesses.
confession. Prosecution said all confession said. They have not said it. It's a confession. They have relied on 161. They have said it's confession. It is I who is saying it cannot be counted as confession. They have to say confession. If it is say it is not, I am true. Their case, it is a confessional statement.
Or it is a statement under section 160.
Well, they have not said, they have said confession only. They have not said statement number 160. They have not stated that. Because it is the accused who can make confession, not a other person. He can make statement. Confession will be accused of either you admit the guilt or something. Confession can be made again by any other person. He can make statement. 164.5.
Okay.
But here, if that 164.2 has not been complied at all. So, Lordship,
Well,
see that
recording statement of PW2 and PW3.
all five, PW2 to PW5. That is not.
But your submission is PW4 and 5 are not.
No,
accused.
I see. They have not truncated. I have truncated. They have not truncated. They have combined it to. They have not made it separate. It is I who have made it separate. They have PW. They all this. They said these people have made confessional statement and they implicated him, and he was bound under confession. But the question is, even if you said it's a confessional statement,
Where they have stated that
see the
they
charge
have.
sheet. Your charge sheet said
Show
all that.
me.
Charge sheet.
Which page?
I just wait the charge sheet. Your Lordship will see page 158. Page 1, isn't it?
Yes.
That's 16.90. Statement under section 164 CRPC of US dated so and so code.
But they have not, where is that it is a confessional statement?
164 statement is.
164, that was my query.
Yes, Your
That
Lordship.
164 statement is not merely a confessional statement. That is your submission.
Mhm.
It can be other statement also.
But question is when you are co-accused.
That
has
is
to
your
be-
submission.
Because see, these people cannot make, if you are co-accused.
Now I have understood. I am trying to understand your submission.
Yes, Your Lordship.
Your submission is that because PW2 and PW3 are co-accused,
Yes, Your Lordship.
therefore any statement recorded under 164 would be a confessional
Confession
statement.
statement.
That is your
Yes, sir.
submission. But that is not their case. They have only mentioned in the charge sheet that their 164 statement have been recorded. They have not qualified the 164 statement as confessional statement.
Then how can you,
So this can be we will hear the other side
no, Your
later on.
Lordship, how can this can be transfer statement? Because if you see section, let's just see.
Okay, I have understood that because PW2 and 3, according to you,
Are
are
co-accused.
co-accused. Therefore, any statement under section
Will be
164
confessional
will be
statement.
confessional
Yes.
statement. Okay.
That is
And
right.
as regards 4
PW,
and 5,
it will be statements only.
it will be,
164.5 statements.
so
They
there,
can, their implication, because there also same thing will come. Because there, see, 164 state, that is why 164.5 is much more weaker because of this fact. Because he has nothing to do, he can implicate anyone. I make a statement, suppose I come and make a statement 164.5.
maybe.
That cannot be used in that form. That's why low evidence, they have said evidence is not there. The court has said, cannot be, you cannot take.
Mr. Chaudhary, I am trying to understand.
Yes, sir.
Suppose somebody has made 164 statement
Yes, sir.
implicating you.
Yes, sir.
That may be used for the purpose of framing charges. Now, whether that can be used for the purpose of convicting you or not, What
That's-
corrode,
that-
that is a different aspect.
That is different.
That
But-
would be considered during trial only.
But question is, can you, in the stage of investigation, can you put this into fact?
Put
that-
this thing in,
Suppose now, if that cannot be used, suppose PW3, that can be used against me. Can it be used for the purpose of paying charges?
statement of PW4 and 5 can be,
State of PW4 is not implicating that. They are just, these people are saying, they are saying that. What PW3 and 4 is, 2 and 3 is, they are saying the same thing.
so is it your submission that they have not implicated you?
I'll
No,
just,
you make clear submission.
yes, yes, I
If
just,
they have not implicated you, say that they have not implicated. I will
no,
not.
they have implicated, I'm not saying that. I'm just,
So your submission is
Yeah,
that
yeah,
they have
give me a minute.
implicated, but this cannot be used.
let's give me a minute, I just point out the, this thing, 164 statement. Let's start from, this compilation D8 it is there, yes. Shall I read the confession statement, Your Lordship? PW2 and PW, just.
No, you have mentioned it in your brief notes
Yes,
about
I've,
164.
yes,
Okay,
I have said
it
it.
will suffice.
Said, Your Lordship, then PW3 also, they have said about the thing, all in PW4, what it says. PW4, may I read PW4, Your Lordship, the short thing. On 37/2007, Your Lordship, I was detained Commander Narcotics Point. This will be a D8, Your Lordship, document compilation D8. So 3/8/2008 at around 8:30 in the morning, my party signaled to stop on suspected vehicle, white color so and so, for checking out, but the vehicle didn't stop and fled away. After a brief chase, the vehicle was instead of Kojima. So while checking the vehicle and reverse 11 packets suspected brown sugar weighing 6.5 back seat of the vehicle. In this connection, we arrested 2 accused, namely Rahul Kharan and Deepak Lamba, and recovered the item says. The matter was informed to the charge as per direction of the higher authority. On being informed through phone IC narcotics cell, he has directed me to narcotics is PW3, matter to SP narcotics, she is PW2. Again, SP directed me to inform the matter to IGP cell. So I called up the matter to IG, but he doesn't pick up my call. So I used another phone call, instance so and so, informed the matter to him, and he directed me to bring the seizure arrested person office, instructed him to disclose the matter to any senior. He further asked me whether a vehicle was sent to bring the accused here, but turned out we came to the accused vehicle. In this connection, I submitted an FIR along with the seizures, product accused person narcotics. That's the first seizure, Your Lordship. This is a person who was the commander of narcotics cell, Your Lordship.
Okay.
As per direction of SP, I along with IC produced a seizure to IGP in his office chamber. After seeing the seizure, the ICDC told me to give direction to sort of SP as to what necessary thing can be done. Later, I directed the SP to release the accused person on paramount seizure by Malkhan that so and so. So these are the allegations. But in the charge sheet, these things are not there. There is no charge that I have allowed them to release. I have gone to scot free, nothing of that. I have not. So charge sheet doesn't say these things. That I refuse to. I directed not to register an FIR, release the accused person, and release the vehicle. This has in the charge sheet, nothing was there. Although this statement he has made it, Your Lordship. This one, so that's Your Lordship. So the only thing is handing over the material to me. He said only that on these 2 dates. These 2 dates on the CDR record will be found to be wrong. These 2 dates. I'll point out this thing. All data records also there. So there's other gentleman also saying the same thing, Your Lordship. On 3/8, as I see information so and so, PW5, received by so and so, and some case are coming to Kuzuma and request on. In the
Your
evening,
submission is that on the basis of the statements of these witnesses,
you can nothing can-
charge sheet could not have been
yes,
filed.
yes. Even the charge sheet doesn't say this. Charge sheet also doesn't say what they are alleging. Charge sheet is going in a different direction. Charge sheet is not saying that I didn't allow you to raise the refuse the DDA, not to lodge an FIR, not to enter DD entry and releasing the accused persons. These are not there in the charge sheet finding. Charge sheet is only on custody of the materials, Your Lordship.
Okay, that you kept custody of the contraband in your residence.
Yes, sir.
That is it.
That's my explanation is that on 6, they said on here they have said on, they talk about 6/8/2018 and 17/8/2018 for the first time here. My case is that CDR records, call data records doesn't support that. They for this call data, I was not in Kohima. They have put me in a Kohima office on that day. On say neither on 6 nor on 17 I was in Kohima. The call data record shows I was in Dimapur and Chumokdima. I was not because call data record they have annexed that D19 the record, 17 I think that record that shows I've given that call data record. So here, Your Lordship,
On which date you were in Dimapur?
I was in Dimapur because what happened, Your Lordship? Third time when the incident happened, I was in the office.
No, there were two dates, 3/8/2018 and
Yes, sir.
1/9. 3/8 is the original date,
Yes, sir.
1/9 is the FIR against you.
Yes, sir.
On which date you were in Dimapur?
No, the 3/8, it's just 6/8/2018, which they said they have given me away. 6/8, what happened, Your Lordship? That
Yes, 6/8 is the,
yes,
when-
6/8 and 17/8. That is here. What happened, Your Lordship?
on these two dates you were not there,
I was not there.
6 and 17.
6 and 17. I was not in. They said they have given this drugs. My case is that on 18 they have given me the drugs to keep in safe custody, and that is supported by call data records also. On 18 I was in Kohima. Your Lordship, the handing over the drugs is not in dispute. The handing over the question is, it was handed over to me to keep in safe custody because the Malkhana and the Rargari does not have proper night security. So I have 24 hours, 7 days. So I was the OC, the PWT requested PWT and PW. They asked me to take back the so that proper security is till that time. So that's the thing. So that 6, my case, I came to know on 18th about the incident here. Third, what happened? Third, this incident happened. Third, I have to go to Guwahati for a conference. Till 5th, I was there. The records, the documents are there. 6th, I came back. I was in Dimapur. I went to the inspection of Dimapur in the CID office and all this inspection. I was in Dimapur. 7th, I came to Kohima. 17th, I was in Sumokdima. I was not in Lok because their case is that they handed over on 6/8/2018. One packet of seized drug was handed over to me in my Kohima office. On 17/8, I asked them, "Do you have they handed over the 10 packets to my residence." So it is not that I kept in the custody. It is not in. They have asked it to be kept because if you see the charges, it was kept in my custody. So kept in custody means it is given by someone to keep in custody. It is not that I was guilty for anything. Keeping it custody cannot constitute the offense under Your Lordship. Then Your Lordship will see. Confession statement, I told you, Your Lordship, this is in comparison D18. D18 comparison. Because what I'll do, Your Lordship, I'll give you a photocopy of my copy. This is all paginated and indexed, so that it will be convenient for. Otherwise, Your Lordship, from the record, it's very difficult to find out because I have seen in the morning I saw it. Otherwise, it was all they have squandered all the 20 volumes I picked up there. No pagination is there. So I have paginated. I just, if Your Lordship permit it, I'll file a copy to Your Lordship for a convenience, Your Lordship. So then Your Lordship. So this I have dealt with Your Lordship. That's subsequent second. Your Lordship, then I have given a page numbers also, yet a compilation also, Your Lordship. Petition page number, annexure, and also compilation also. Because Your Lordship, then I come to there was non-compliance of provision of CRPC, Police Act, Nagaland Police Manual in respect of making of GD entries and Jimana. This is also very important. What happened, Your Lordship? If Your Lordship see the provisions, Your Lordship, who is responsible for making GD entries and FIR, registration FIR? It is the OC of the police, not the IGP, Your Lordship. So, Your Lordship, for that, in the petition, I have extracted the relevant rules, Your Lordship. There are Police Act provisions, I have put it there, Your Lordship. Whereby the duties of IGP and has been stated, Your Lordship. That is, Your Lordship, just take Your Lordship there. Page 52, 53 of the paper, Your Lordship. Page 52, 53. Your Lordship, page 52, Your Lordship. Because that duty is whether, because they have made a charge that I refuse to counter that charge, Your Lordship. Page 52, section 4.
What charge in the charge sheet?
No, so this is not the charge sheet, but they have allegations are all based on this, it was mounted on this. That's why I pointed out, because whose duty is that? Provision, because statutory provision is not my responsibility at all. They orally they said they said orally said I have stopped them making an FIR. FIR is a duty of the OC, not.
But this is not the basis of framing, submitting charge sheet.
Because it is all jumbled up, Your Lordship. That's the whole problem. It's totally jumbled up. What they are saying not very clear. That's why I have to deal with all the provisions, Your Lordship. Because the whole, if you read the charge sheet, it's not very clear on what basis they have come to that conclusion. Your Lordship. So that's why I'm going to duties also, so that things are very clear. You will say section 4 is Inspector General of Police. The administration of police throughout a general.
Okay, I'm cutting short. Assuming that it is not your role,
Yes, sir.
then what is your submission?
They are at fault. PW2 and PW3 are at fault.
That is not the basis for their laying charge sheet.
You know, that's it. It's for that reason they have implicated me. All things are orally, Your Lord. Nothing is on written. Orally, or he said he has taken it. Your question whether they said orally, they said I didn't allow them to register. I allowed the accused to go. I allowed this thing. So
No, but now you are challenging the charge sheet.
Yes, Your Lord, charge sheet. But while challenging this, I have to point out the legal issues also. These legal issues on who is responsible, because PW2 cannot escape the responsibility. They have acquitted PW2. Because PW2, because under this PW2 is responsible for registering. She has not registered on 3/8/2018. That's why they have avoided mentioning about that. Why she did register a complaint on 3/8/2018, Your Lordship? And who is going to maintain a GD entry? Not GD entries have to be maintained by them. So there's no question that I said not to make a GD entries, Your Lordship. Section 44, Your Lordship, of the Police Act. Police officer, it is a duty of every officer in charge of the police station to keep a general diary. Page 52 is clear, Your Lordship. The provision, name of the person and so. Then your Nagaland Police Manual, I have given the compilation, if you should see. So that is not available yet. I have given that written submission, that compilation I have given, Your Lordship. Nagaland Police Manual. The provisions are there also. So Lordship, see this.
Okay, I'm assuming that it is not your role.
Yes, sir.
Then proceed.
If it is not my role, then I cannot be prosecuted for that. I cannot be liable because that cannot be material to use against me. That's what.
No, but the allegation against you is that you unauthorizedly kept the ganja in the brown.
Whether it's unauthorized or that has to be determined. Unauthorized, how it is unauthorized?
No, but that
They have, because what they said, they are keeping it, and the dates are also given wrong. See, Your Lordship, that cannot be an offence under so and so 409 and 420. That cannot be offence under PC Act. That cannot be offence under even NDPS Act also, because the forensic report is saying something else. FSL report. They have charged me for commercial quantity, but FSL report is not supporting anything. FSL report is not supporting their contention. And your lordship, what has happened? The drugs were kept in the Malkhana for it was seized on 1/9/2018 from me, your lordship. Then on 5/11/2000, they deposited when I raised an objection that this is still in the custody of police. So the drugs were given on 5/11/2018. It was in custody of the PW2 and the ADG, your lordship. It was custody of PW2 and 3. So nothing has been, how can they keep it's a violation of section 102 subclause 3 of the CRPC, your lordship.
No.
Okay. The seized drugs were in the.
Don't mix up
No,
everything.
your lordship, I'm just giving an example. Why?
I don't want examples.
No, what I'm saying,
You go one by one.
I'll go one by one. I'll come to
My query is pointed towards
Yes.
your submission
Yes.
regarding this non-compliance of CRPC.
yes, not compliance, sir. Because
That you come to next point.
yes,
what
not
is-
compliance CRPC. Then your lordship, the Nagaland police manual also says that you have to make general the PW2 has to make general ID entry and listing all this PW2. Rule 58, 30, 31. That 30, these I give the rules also. your lordship.
No, that I have
Ah.
already
Yes, that is there.
assumed that there is,
Uh-huh.
you are not bound to make GD entry.
Yes. Now your lordship will see under the All India Service and Conduct rules, your lordship. There is, if there is an oral instruction, they say oral instruction, it has to be reduced to writing, your lordship. That I have given that rules also, it is there in the compilation, your lordship. That All India Service rules, your lordship.
Okay, now what is your point? That you made on your oral request,
Huh.
the contraband was given to you.
Yes.
That should not have been given to you unless there is a order in writing. Is that your, sir?
Question is oral instruction is on that. Their allegation made against me.
That not to.
Register FIR and all
Not to
those things.
register FIR. Okay,
That service will sit there. I
so
think.
they should not have complied with that oral instruction.
Or because it has to be in writing. If that rule says rule 3.5. If your lordship say written submission is there, your lordship. That rule I will accept that pages. That I have. And here, your lordship, if your lordship see rule 3.3, the written submission, your lordship.
Yes.
It is the written cover. No, my lord has got it. It is All India Services Conduct Rules 1968. It says no member of the service shall, in the performance of his official duties or exercise powers conferred on him, act otherwise than his own best judgment to be true and correct, except when he is acting under direction of a official superior. The direction of an official shall ordinarily be in writing. Where the issue with the oral direction becomes unavailable, the official superior shall confirm in writing immediately thereafter. Then a member of the service who has received an oral direction from his official superior shall seek confirmation of the same in writing as early as possible, and in much case it shall be a duty of the official superior to confirm the direction. So here there is no allegation that they have not said if I have given an oral, they should ask insist me that I should give in writing. That has not been done. That's not an allegation.
So PW2 was at fault
Yes, sir.
by not asking
Yes.
for written
Written.
direction.
Yes, sir.
Okay. Then
She is also an IPS. Then your lordship. Then next is non-deposit of the in the quota C suspected drugs, your lordship.
okay, what is the submission?
Your lordship. That is your lordship. Here what happened? The drugs were taken from me on 1/9/2018, your lordship. Even according to prior to that, from 3/8/2018 till 18/8/2018, the drugs were in possession of the police, Malkhana, Your Lordship. On 18 to 1st, it was in my possession, Your Lordship. Then again, from 1st to 5/11/2018, these drugs were again in the police station, Your Lordship. Lying in a police station. And on 5/11/2018, when I surrendered before the court and took bail from the court, I pointed out that the drugs are still in the custody of the police, Malkhana. Then the court directed them to immediately deposit that. On 5/11/2018, they deposited drugs in the court. So 1/9/2005, it's a long period where drugs could have been changed by that victim.
Okay.
Then Your Lordship, this is a violation of section 102, subclause 3 of CRPC, Your Lordship, because it is said immediately you have to deposit the materials to the court and not afterwards, Your Lordship. You cannot keep the seized drug in your custody.
So according to you, this is also one of the ground for quashing
Yes, Your Lordship.
charge sheet.
Because the question is, the drugs will be changed in between. Why they have for custody? And it has been changed also, because the forensic report is saying something else. Because if Your Lordship see, so far, when these materials were sent for forensic report, Your Lordship, the respondent in compilation D3 also, there's a letter, but I have not annexed it yet in a compilation. I'll give it to you. Yeah, I have extracted that portion, the relevant portion in my petition, Your Lordship. It is at page, I just give you the page, Your Lordship. Page 85, Your Lordship, of the petition. Okay. Page 85 of the petition. My para 89, the letter dated 4/12/2018, it is in compilation D3, has sought the expert opinion on 4 issues, which are as follows. Whether the suspect as a marked exhibit 1, 2, 3 are prohibited narcotic drugs. B, if so, what is the market value of the product? C, what is the purity of the items marked in exhibit 1 to 7? Please fund the estimate market of the said exhibit so and so. So Your Lordship, the CFSL report has said nothing on that. They have given this opinion only. Para 90, CFS letter is so and so, opium alcohol so and so, morphine, considered market value so and so, Your Lordship. So they did not reply to any of the queries, Your Lordship. Now, Your Lordship, so even in the report also I have annexed it here. It is at page 198 of the PDF paper, Your Lordship. The FCFSL report is there. The full report is there. Page 198, annexure page 26, Your Lordship. It is in compilation. I just give you, Lordship, compilation. This report is compilation.
Yes, what is there in report?
If
No,
Your Lordship will see,
what
here,
point?
this is the forwarding letter next.
No, what point you are emphasizing?
So, Your Lordship, what they are starting, because here doesn't say that these are the drugs proportion of what drug, they have not stated anything. Because for commercial quantity, it has something else. What they are saying that duly say so and so, yes, which is marked, Your Lordship will see here. The report is here. Next page, results of examination. Opium alcohol so and so, here so and so. Here, actually, Your Lordship, the person, nothing has been mentioned here. So forensic report is not supporting them, what they are trying to build up the case against me, Your Lordship. CFSL report is, because their query is something else. CFR not going to the question, that means they have rejected those things.
No, what is your submission that result of examinations shows that the
Hmm.
sample contained opium alkaloids,
Ah,
morphine, codeine, and some other materials.
Hmm.
What is your submission? These are not prohibited
So
contraband.
question is this, what they are asking is not the same. Because for commercial quantity itself something else, your lordship. Because they are charging on 21C, this is a commercial quantity, NDPS. This commercial quantity, 21C, they have
No,
condition.
but commercial quantity will depend only on the weight.
No,
For that forensic has to,
So your lordship, if it's some grass and something for that, because quantity has to be there. It is not the weight. Your lordship see 21C. I just 21C.
no, Mr. Chaudhary.
Yes, sir.
Is it your submission that the forensic report does not detect any prohibited
No, not to the extent, your lordship. It's not to the extent what they are saying. 21, how 21C will be implicated? 21C will come. If your lordship will see, your lordship will see it here. Whoever in contravention of any provision of this act or any rule made, section 21, I'm reading, your lordship, on condition of license granted thereunder, manufacture, I'm not a manufacturer, possess, sales, purchases, transport, import, interstate exports, or uses manufacturing any containing benefit shall be one. Your lordship, here, whether I possess or not, that is important. Possess is important because it's not possession. Possession is you are giving me to keep in cash. That is that amount, that doesn't amount possession under the act.
Okay, that is your submission.
Yes, sir. Keeping in custody, they are kept in my custody, kept in my personal custody, kept in personal custody, and possession of drugs is something two different thing. Possession is I have taken someone I in possession and you have seized it. It is not that I have given you, we keep it for the see police has the authority here. If some third person gives, not a police officer, then I may be prosecuted because he is also. But a police officer is giving me to keep in custody. So police officer is having lawful custody of the drugs. He is giving me to keep in custody.
Okay, your submission is that you were lawfully possessing the,
I'm not
lawfully having custody of the.
custody, not possession. It is not.
I
So
have-
section 21 is not attracted. Culpability is not there, your lordship.
But what relationship it has got with the FSL?
No, what I'm FSL report, I'm trying to FSL reports are what charges, section 21. That's why that 21 is not maintaining against me. That's why I try to bring because I'll discuss later on all that also. Because why I'll elaborate further later on because why I'm saying this because your lordship put a query that this material have been found against you. I thought that. Question is the material is there. Whether seizure, here is seized from me, it's not seized from it's not a seizure, it can be a second seizure. Kept in custody cannot be a seizure. If you are allowing me to keep it in custody, it is not a seizure. And suppose you have given me 1830, what you are doing for so long? So your lordship. Then. So that's why I'm telling you, that's why it doesn't come on a 21C also. 21 is not everyone. 20, I have to manufacture, it's not possession also. It's only because I am not manufacturer, trader or anything, not a licensee also. So 21 is not attracted in any case in my case. That I'll do later on also, your worship. He said manufacture condition of license granted under I am not a licensee also.
No, I have understood your submission. Your submission is that 21C is not
attracted. Because
attracted
I am not
because
in
you were not-
21 is not attracted. 21 is also 21C also doesn't come.
Okay.
Main solution. Then your lordship, I come to CDR call data records, your lordship. Call data record is compulsion D17, your lordship. Your lordship is not having it because I supply all these things, your lordship. Call data record, your lordship, is there. They have seized my telephone also, my mobile, along with the officer also, PWT also. They went to BSL for the call data records certified data. So they have submitted a report that is complaint D17, your lordship. So D17, your lordship. The call data records because call data records only, because they said they inform on telephone, call data records only gives you the location and the time of a place of the person who is having it, your lordship. So if your lordship on 6, it is page 5 of this, your lordship, page 4 and 5 of that this thing, D17, your lordship. It talks about he's in Chumukdima on that day. Chumukdima, all this chassis. He was not in Kohima. Then that is 4 and 5. Then page 7 of the D17, it talks of 17 August. He said festival Chumukdima, all Chumukdima, your lordship. So he was not in Kohima office. So this shows he was not on that date when they said they have handed over this thing, and the GD entry has been, he was not there on Kohima. So it cannot be handed over on 6 and 17.
Okay.
That way. So your lordship, what I'm saying, the CDR call data records did not support the case that these drugs were handed over to me on 6th and 17th.
As because you were not in
The
Kohima.
Kohima. Because they say handed over in my Kohima office. They didn't say I handed over to be at Chumukdima or Dimapur.
Okay.
That way. If your lordship see the GD entries also, that is right. GD entries. Because here I have already stated here what I have stated earlier also, that page 22, I have just dealt with those things, your lordship. I just the fact that there are LHGD entry that so and so was for the first time stated in a second charge sheet. That is so. There was no statement of by any of them that there were GD entries made on those dates before delivering the LH suspected concept. It clearly proved the fact that these GD were made.
Mr. Chaudhary, what I propose,
Yes, sir.
instead of your repeating things.
Yes.
Because you have already submitted
Hmm.
a written
Yes, sir.
gist of your
Yes, sir.
submission.
So I have to point out this thing also.
You will get chance to reply.
No, the provisions I have to give it out. How the sections are also not attracted. Because I have to go to that also. No? Your lordship.
How much more time would you require?
Sometime.
Because it
One.
will not allow you to continue beyond today.
Your lordship. Yes. Because that's why I didn't read that. I just gave all the because it.
Because unless we hear you will also reply to what public prosecutor will submit.
Because I request sometime on the next day or sometime.
Your reply portion will.
No,
also
no,
be-
just I request another 15 half an hour on next day also. To complete.
For making your submission.
Another half an hour.
Ms. Sokre, how much time will you require?
For me too, I won't take much time, but your lordship, if my learned friend is going to complete, let him complete it today, so that on the next day, I
Definitely,
updated my submission.
Okay,
And,
okay, continue.
Then your lordship, I come to the GD entries and Jimma, your lordship. It is at page. So I have made some charts also here for a comparative analysis of all the things your lordship. That I also referred your lordship. Your lordship see this VT entries. Page 192.
Regarding GD entries and Jimanama, your submission is that
Yes, sir.
that these dates,
Ah.
these GD entries were mentioned in the charge sheet for the
Ah.
first time without
First time.
there being any material.
Material there. And this has been made subsequently, afterthought. Because till that recording of confusion, the entries were not, they have not mentioned of GD entries. Till 2019 also they are not there.
Okay.
Because their confession said doesn't state about GD entries being made. They said 6, 7, 8, their dates are mentioned that handing over in his office, but no GD entries was mentioned. And if your lordship will see this, I have this NHR P24 Malkhana register, if your lordship see. Page, it starts from page 191.
What it says?
If your lordship see page 192, yeah, but if your lordship see, all this matter are forwarded to here, this matter is not there.
No, what is not there?
Here in Malkhana register, if you see page 192, they have interpreted, they have put it that as per the direction of IGPCI, one packet of bronze was handed over to him as his office chamber and so on, GD entry is made GD. So these are all subsequent made, your lordship. Here, if you said nothing was mentioned, so here all cases have been referred to the court. This is the only case which is not referred to the court till today. According to this report, your lordship, in the chart sheet. So if your lordship, then again 17, that next is 17.8, that is also next year. The handwriting is the handwriting entered in 3 and 8 and entry at 6, 8, 17 events is made by different individuals. The entry is made in columns 5 and 6. Recently visited the code. How much could be so and so? Your lordship, if you see the original thing, everything will become clear, your lordship. Original is here with me, but these things had to be. So GD entry also, if your lordship, Malkhana register, they have not followed the code at all. This is clear. That's because in other matter they have all followed the code. It's a police station. Only in this case they have not done it.
They have not forwarded the
To the court.
contraband.
Yes. They have
Received
not-
materials. to the
Yes,
court.
sir.
Okay.
And GD entries also showed here. If you're 188, the GD entries are there. Page 188. Now, as directed by the IGP said, these are all interpreted later position here, not at that point of time. Your lordship.
And
These
what-
have been subsequent to confessional statement because then GD, because they found nothing is there, so GD, they put the GD entries also. And these are not assigned by the SP only. She has signed it later on. But she has not, this PW2 has not stated in the, she has signed it, PW3 has also this thing, but they have not stated in the statement at all.
That,
That 6/8/2018, they made GD entries.
okay.
Because 6/8/2018, the entry has to be made on 6/8/2018, not subsequent to 2019, your lordship. Because they have not stated this thing, so GD entries, this is there, your lordship. So your lordship will see, even the Malkhana register which they have given, 2 sheets are missing. That was stated there also, because compilation, there's a top 4 sheet, but there are 2 sheets only. All those things your lordship did. So then your lordship will see. What I saying, there are a lot of contradictions in the statements, your lordship. And your lordship, I have prepared some charts. It is in annex here, your lordship. One relating to your lordship. One relating to your lordship is the statement made by different witnesses, that is page 166. Page 166, my lord is got it. That statement, comparative statement I made from the records, your lordship. This is from the records. And the remarks I have made it is my remarks, your lordship. So statement of that complaint I have reviewed, your lordship. Then your lordship, this is first is PW4, your lordship. PW4 statement, my lord, is page 168. That's the relevant. He he made a statement to IGP CID that on 28/2018, that 6:37 so and so, Maruti Swift, he said. Now 161 statement, he said, seizure made around to 8:30 and 3:00, reported to NFO so and so 10:30, as Director BS, he was taken to IGP of chamber, taken to IGP of CID of chamber, and thereafter kept in narcotic malkhana. On direction of IGP CID, 2 accused were released. On prayer, no regular case was registered. On 6/8/2000, this is 6/8, Your Lordship. On IC narco UBI asked him to accompany him to IGP along with 1 packet of so and so, narco returned to his office. So these are the allegations. 17A, these are the allegations. Now, Your Lordship, he made a statement under this, or reported to AG so and so. That's it. So if Your Lordship see section 164 statement made by PW4, Your Lordship, he called the then IGP CID in his mobile phone, but IGP was not responding. He used the phone of 1 constable. So reporting incident so and so, reported the narcotics along with written FIR, seizure memo, 2 accused, seized better. He has stated all these things, but he is emphasizing that 3/8 he has made a complaint. But no, they are not totally brushed aside those things, Your Lordship. Even seizure memo. Directed the seized item kept the narcotic malkhana. Later on, the CBI directed SP to release the 2 accused. Now on 6/8 to the accompany so and so interesting. Now, if you see the comments, so the first statement says around remark 10 hours. The second statement says 10 times. Times are also different. 10:30. There is no mention of timing of the third. Admitted the written FIR and submitted by on admitted seized BS brown sugar was kept in the narcotic malkhana. So no official proof, written order, written which I was telling you, Your Lordship, read so and so test 2 accused person respective ideas. On 6/8 to the CDR shows then IGP CID was in Dimapur near IDGP office. Locally, he was visiting the CID office and police commissioner Dimapur on that day. Only on 7/8/2000 he was shown to be present in Kohima. That's the record says. So these are just this compare a full thing. I've made it tabular from here so that it becomes easier for a Lordship to see the comparative statement here also. Your Lordship can verify the records also. But I have done it myself from the records, Your Lordship. So 7/8 and shown to me. So how can a person 2 different at the same time 74 kilometers? The GD entry is fake and false. The statement of handing over 1 packet and cooked is cooked so and so. He has contradicted the statement. Here he also he has contradicted the statement of PW2, his PW, that it was on 18 and the 10 packets were BS are handed over to I. So he has contradicted the statement of PW2 3 Your Lordship. That PW he is also admitted on 1 ADGP Reno so and so, went to the official IGP so and so, BS so and so. So Your Lordship, then comes the statement of PW3, Your Lordship. PW3 is also there. PW3 statement also there. PW3 statement starts from page 171, Your Lordship. What is that report? I was talking about the report. All these things are the report. He said at around 10 hours, the timing got changed. On 3/8 commander so and so reported so 2 accused Maruti Swift so and so as directed through phone. He and commander went to the IGP along with the CID, all oral thing. He requested us IGP to register so and so. Your Lordship, on 3/8/2018, IGP didn't meet anyone of the he was on his journey to Guwahati for that attending a conference. That documents are also annexed here. He was, although he was in Kohima, he was just came for some official or he went away. So these things are not brought to the record at all. So he went on 3/8. He attended the conference. So he was not there. He requested the IGP to register the case. On that date, 3/8. The IGP directed to keep the brown sugar and narcotic malkhana. SP narcotics are reported call so and so. Here, if you compare 3, if your Lordship para 3 with para 3, then the whole thing comes out. It at around page 170, at around 10:30, listening to his PW5, Your Lordship. PW4, reached narcotics with 2 accused and Maruti Swift. He then 164 statement, he said he and SI went to IGP CID office and showed the BS before leaving his office room.
Okay, so your submission is that there are contradictory
Contradiction.
statements. So,
This such are there.
so your submission is what?
There contradictions are totally there because nothing could be varied on this thing. Contradictions are there. This chart, because what they are saying here is totally contradictory here and there, Your Lordship.
No, whether
Yes,
in a washing application,
yes, sir.
these things can be gone into,
So records can be gone into, records can be gone into.
whether there is contradiction.
No, records, if your lordship see that some things are missing, you can, you have the power. 1/480 to power is a very large with your honorable court, Your Lordship. You're,
It has to be rarely exercised.
no, rarely, but they're rarely expert, it should be in cases also. Rarely exercise doesn't mean that your lordship do not exercise, because there's no bound for your lordship. It is a self-imposed limitation. It is self-imposed limitation, it is not,
Okay, your submission is in view of these contradictory statements.
yes, sir.
Charge sheet ought not to have been
Yes,
filed.
sir, correct, because they're basically on 60 and this thing, no, your lordship. Then your lordship. Then I take I have to go through the chart sheet here also. Chart sheet, I have to go through the chart sheet also. Your lordship. That is also very important. Chart sheet. Take the chart sheet also. That page. Page 152. Yes. Chart sheet, your lordship.
We'll stop here now. How much time will you require?
Half an hour.
Half an hour,
Yes.
not more than half an
Yeah,
hour.
and I'll finish. I'll finish. Because I've just rushed through, and if your lordship permit, shall I submit the records? We photocopy it, so it will be convenient for a lordship. Well, otherwise, there's no indexing, nothing is there.
No, you may submit.
I'll do that.
No, your lordship, my prayer is that on the next occasion, let me submit first.
That also we can do.
Yes, otherwise, your lordship, you will take more time, yes.
You
So let
can
me finish,
reply,
yes.
in reply, you can continue.
Yes,
You may take that half an hour while replying.
No, yeah,
Because
before I finish. Because
This you have,
no, I
already-
have not gone to the charges. I've not gone to the charge. I've not charge sheet. I have to deal with charges. I have not done.
otherwise, lordship, if we keep on continue, it would take more days. So your lordship, on the next day, let me.
I'll not
submit.
allow. more
Half an hour. I'll take
more
half an.
than half an hour.
I'll finish.
More
Half an
than
hour.
half an hour.
I'll finish it half an hour. I'll give a statement. I'll finish it half an
When would be convenient for?
hour. Tuesday, you're not next week.
No, lordship, I have difficulty,
Not
so your lordship
Tuesday,
may fix
Because
on,
I'm having division bench,
Or
yes.
Monday also you can have it.
No, lordship, on
Because
2nd of
already-
February,
Monday.
not Monday.
2nd of February, your lordship, because I have other engagement.
2nd February.
No, you're then
That's on
I have to
Friday.
go back here. I can stay back here. I have to go back to Delhi.
Then you suggested it.
Your lordship may have it sometimes in February. The 13th holiday, or I don't know.
Because you have, in written submission, you have already,
No, because charge sheet I have to deal with, orally I have to deal, your lordship. And your lordship may give me sometimes in the 15th of February, if your lordship, the holidays, I think holidays are there. I don't know, the holidays or not, I don't know. 14 is a holiday, I think. 14. I don't have the calendar.
15th February is a working day.
15. 13, your lordship, 13.
No, 15 is okay.
15, yes, the 15 of 15 years.
Is it okay?
Okay, okay, lordship.
15th, heard Mr.
15 February.
P. Chaudhary, learned senior counsel, assisted by Mr. D. Talukdar, learned counsel for the petitioner. Also heard Ms. B. Sokre, learned additional AG.
Lordship, PP here.
She's people.
Ms. B. Sokre, learned public prosecutor, Nagaland. The hearing remained inconclusive.
Tuesday, no?
It is hereby
Can it be the 15th? 15 is the day. 16 Friday.
15 would be a hearing date for this.
Hearing date. 15.
Though learned counsel, senior counsel for the petitioner made a lengthy submission However, he has further submitted that he further needs half an hour time to complete his submission, which is allowed. On the next date, he will make his further submission. That is on 15th of February. Let this case be accordingly. Learned Learned Senior Counsel also submitted that he would like to assist this court by submitting a compiled
The documents are the D1 to D20 come with the index
compiled
of the charge sheet document.
charge sheet documents. Same is allowed. He may file the said documents on next day.
I'll do that, because that will be convenient for your lordship, otherwise.
Let this case be listed at 2 p.m. on 15
Number 2, no?
15/2/2024.
Deeply obliged, Your Lordship.
But
Very highly obliged to be a patient hearing. Your Lordship.
I think I was not patient today.
You are patient, Your Lordship. You are very patient, Your Lordship. Rather, I was impatient slightly.
Yes.
Item number 2, my lord.
It is also part heard.
Yes, my lord. That can be taken on 22nd February, my lord.
Okay.
Yes, my lord.
Item number 2, heard Mr. NNB Chaudhary, learned public prosecutor,
Yes, my lord.
Arunachal,
And he is, my lord, it is a joint payer, my lord. He is also.
Arunachal
petition.
Pradesh, as well as heard Mr. D.P. What is your name?
D Devi.
D. Devi, learned counsel for the petitioner, who submits that as this matter could not be taken up today due to paucity of time, same may be fixed on 22nd February. The prayer is allowed. You are also there.
Yes, my lord.
For
I am for item number 1. C is for respondent number 2.
also are Miss B. Chaudhary appearing for respondent number 2, who does not oppose the prayer. Let this matter be listed again on 22nd February
Yes,
at 2 p.m.
yes, ma'am. Proceed me. I am for item number 1. Okay. CD was called for.
She did not.
Can leave an issue reminder.
On
4th
Item number 1,
Yes,
heard
yes.
Mr.
Arho.
R. Hawk, learned counsel for the petitioner. Why it is fixed before this court? Is
Because it is rejected.
rejected, okay,
Reject.
okay. Also, heard Mr. K. Das, learned additional public prosecutor, who submits that the case diary which was called for has not arrived, and prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
6th February.
6th of February. You are on interim? No.
No.
No, okay. দেখা এইটো রেকর্ডটো সিস্টেমেটিক কৰি ভিতৰত দি দিম।